A legal motion that was fully alive on Monday morning became completely irrelevant by Monday evening, not because a court ruled against it directly, but because a separate ruling made the entire question moot. That is exactly what happened to President Trump's attempt to claw back $5.6 million already paid to E. Jean Carroll, and understanding how one court's action can instantly erase the relevance of a motion pending in a completely different court tells you something genuinely useful about how the appellate process actually works. Today we are going deep into the specific legal mechanics behind this ruling, the rehearing petition, the clawback motion, and the concept of mootness that ultimately decided how this entire sequence played out. Before we get into the mechanics, if you want to understand the actual legal machinery behind a ruling like this one rather than just the outcome, hit subscribe, because these kinds of procedural interactions between different courts happen constantly in high-stakes litigation, and they rarely get explained in enough detail to actually make sense. Tell me in the comments, once you have heard how this specific sequence worked, whether you think the legal system handled the overlapping timing between two different courts efficiently. Because I think this case is actually a pretty clean example of how that coordination is supposed to work when it functions properly. Let's start with the specific legal tool Trump's team was actually using here, because a petition for rehearing at the Supreme Court is a genuinely unusual step worth understanding on its own terms, rather than assuming it functions like an ordinary appeal. When the Supreme Court declines to hear a case, which is what happened here in June of 2026, that decision is typically close to final. The court denies far more petitions seeking review than it grants, hearing only a small fraction of the thousands of cases parties ask it to review each term, and a straightforward denial usually ends the litigation at the federal level entirely, leaving whatever the lower courts decided as the final word. A petition for rehearing asks the court to reconsider that specific denial, essentially asking the justices to take a second look at their own decision not to get involved in the first place, a request distinct from asking the court to actually rule differently on the underlying merits, since the court never reached those merits at all when it simply declined to hear the case. These petitions are granted exceedingly rarely, since the court's own internal rules set a genuinely high bar for reconsidering a decision it has already made, and parties generally file them knowing the odds of success are quite low, often as a final formality before accepting an otherwise final outcome, or in some cases, as a deliberate strategy to buy additional time before a judgment becomes fully enforceable. That second function, buying time, is exactly what makes this case interesting as a piece of legal strategy, regardless of how you feel about the underlying dispute. Once the Supreme Court denied Trump's original petition in June, the practical mechanics of the case moved forward in the normal way. Judge Kaplan, who had presided over the original trial, ordered the escrowed funds released to Carroll, treating the litigation as effectively concluded now that the highest court had declined to intervene. Trump's team then filed the rehearing petition and simultaneously argued to the Second Circuit that the fund release itself had been premature, specifically because that rehearing petition remained technically pending. This created a genuinely interesting procedural situation. One court, the district court, had already treated the case as resolved and released the money accordingly, while a request remained alive at an entirely different court, the Supreme Court, that could theoretically still reopen the underlying question. Here is where the concept of mootness becomes the actual key to understanding what happened next, and it is worth explaining this legal concept clearly because it does genuine, decisive work in this specific sequence. A legal question becomes moot when the circumstances that made it a live, decidable dispute cease to exist, meaning a court no longer has anything concrete left to actually rule on, regardless of how the underlying merits might have come out if the question had remained alive. Federal courts generally will not issue rulings on moot questions at all, since federal judicial power under the Constitution is limited to genuine, live cases and controversies rather than abstract or hypothetical legal questions, a foundational limitation on what courts are even permitted to decide. Trump's clawback motion at the Second Circuit was built entirely around the premise that his Supreme Court rehearing petition remained pending, since that pending status was the entire legal basis for arguing the funds should not have been released yet, or should be pulled back in the meantime. Once the Supreme Court itself denied that rehearing petition on Monday, the premise underlying the entire clawback motion evaporated instantly. There was no longer any pending Supreme Court proceeding that could justify treating the fund release as premature, Because the preceding Trump's argument depended on no longer existed in any live, unresolved form, leaving the Second Circuit with nothing left to actually rule on regardless of what it might otherwise have concluded about the merits of the clawback request itself. This is exactly why the Second Circuit had strategically chosen to wait until Tuesday before ruling on Trump's clawback request, and understanding that timing decision reveals a kind of practical judicial efficiency worth appreciating on its own terms. Rather than ruling on a motion whose entire legal foundation might disappear within 24 hours depending on what the Supreme Court did, the appeals court simply waited to see what would happen at the higher court first, a deliberate, sensible sequencing choice, rather than mere scheduling coincidence. This is a genuinely sensible approach to judicial economy, avoiding the possibility of the Second Circuit issuing a ruling on a now irrelevant question, only to have that ruling itself need to be reconsidered or vacated once the Supreme Court's own action came down, which would have wasted both the court's own time and the parties' resources on a question that was about to answer itself regardless of what the appeals court concluded. By waiting, the Second Circuit avoided doing unnecessary work on a motion that the Supreme Court's Monday ruling was about to render entirely academic, regardless of how the appeals court might otherwise have decided it. A small but genuinely instructive example of courts at different levels coordinating their timing sensibly rather than working through overlapping questions in isolation from each other. Now let's talk about what the unanimous nature of Monday's specific ruling actually signals, because the detail that there were no noted dissents from any of the 9 justices carries real information, distinct from the earlier June decision not to hear the case at all. Denying a rehearing petition unanimously, without any justice publicly noting disagreement, suggests the court viewed this specific request as genuinely lacking any additional grounds worth even a brief separate mention, as opposed to a closer call where one or more justices might have wanted the court to take a second look or write separately to explain a different view. Given how rarely rehearing petitions succeed in the first place, a unanimous denial here is not necessarily surprising, but it does confirm that none of the 9 justices, across the court's full ideological range, spanning justices appointed by presidents of both parties over multiple decades, found anything in Trump's rehearing arguments compelling enough to warrant even noting a dissenting view, let alone actually voting to grant reconsideration. That kind of unanimity across ideologically diverse justices on a discretionary procedural question like this one is itself a meaningful signal, since it suggests the request fell well outside whatever narrow band of circumstances might genuinely divide the court's members on a closer, more contested question. There is a broader lesson here about how litigants sometimes use procedural mechanisms less to actually win a case outright and more to extend the practical timeline before an unfavorable outcome becomes functionally final, a distinction worth drawing out clearly. Filing a rehearing petition and simultaneously arguing that pending petition justifies delaying or reversing a fund distribution is a recognized legal strategy for buying additional time, even when the underlying odds of ultimately prevailing are genuinely low. That strategy is not inherently improper. Parties are entitled to exhaust every legitimate procedural avenue available to them under the rules, and doing so is a normal part of vigorous legal representation rather than any kind of abusive process on its own. But it is worth recognizing this pattern for what it functionally accomplishes, extending the practical timeline of a dispute even after the core substantive questions have effectively already been decided by the courts that actually have authority to weigh in on the merits, delaying the point at which a prevailing party can actually treat their victory as fully secure and final rather than still theoretically subject to reversal. Step back and look at what this entire procedural sequence actually teaches about how the appellate system handles this kind of overlapping, cross-court timing question when it works as intended. 2 different courts, operating with different but related questions in front of them at the same time, coordinated their timing in a way that avoided wasted judicial effort, letting the higher court's more directly relevant action resolve the underlying premise before the lower court needed to rule on a motion that premise had been built around. That is not a dramatic story in the way a single sweeping ruling might be, but it is a genuinely instructive example of how the machinery of appellate litigation is actually supposed to function when multiple courts have overlapping, related matters pending simultaneously, each aware of what the other is doing and coordinating their timing accordingly, rather than working in isolation. If breaking down the actual mechanics behind this ruling, the rehearing petition, the mootness doctrine, and the coordinated timing between 2 different courts, gave you a clearer sense of how this kind of legal maneuvering actually works, hit that like button so more people understand the real machinery underneath the headline outcome. Subscribe, because these same procedural tools, rehearing petitions, mootness arguments, coordinated timing between courts, show up constantly in high-stakes litigation, and understanding them here will help you follow similar disputes as they develop elsewhere. Drop a comment telling me whether you think using a rehearing petition primarily to delay a fund distribution, even when the underlying odds of success are low, is a legitimate use of the appellate process or a strategy that stretches the system's patience further than it should.